The week started with the Independent National Electoral Commission being able to call one witness in the petition of the PDP and Atiku Abubakar. The witness, Dr. Lawrence Bayode, is an ICT expert who adopts his deposition before the court. Led in evidence-in-chief by the INEC counsel Abubakar Mahmood, the witness identifies a cloud trail log while making reference to the glitches during upload of results. The log is however admitted as evidence before the court amid objections by the PDP. Bayode also confirms that results transmitted electronically or manually would not affect integrity of election. He also confirms that the commission does not have any electronic collation system for the election results, and that a few days to the election, the commission had published in the Tribune newspaper that it would not transmit results electronically. Under cross-examination by the petitioner's counsel, Chris Uche, the witness admits that not all results were uploaded before the declaration of Bola Tinubu as president. He also tells the court that no formal report was sent to Amazon Web Services by the commission on the issues it claimed to have encountered. A copy of the final results of the European Union Election Observation Mission was also tendered by the petitioners, and the witness was made to read out a part of the report which highlighted that only 31% of the results formerly uploaded on IREF server were mathematically correct. Expectedly, the respondent raised objections to the admissibility of the report.
The European Union Observation Mission, their final report was today tendered and admitted in evidence by the court. And you see that the witness who came from INEC, a director from INEC, read out the findings in that report, which clearly stated that the election fell below expectation, and that only 31% of what was reported was mathematically accurate. So we think that this is a very good one.
Day 2 of the proceedings, President Bola Tinubu opened his defense in the petition filed by Atiku Abubakar and the People's Democratic Party, seeking to upturn the outcome of the February 2023 presidential election. President Bola Tinubu, who is the second respondent in the petition, opens his defense with the tendering of about 17 documents before the election court. The documents tendered are copies of letter from the United States Embassy to the Nigerian police dated 4th February 2003, as it has to do with the status of Tinubu's forfeiture case, which the petitioners have raised to argue that he was not qualified to stand for election. Also tendered was a bundle of Tinubu's academic records from Chicago State University, as well as Tinubu's immigration documents and United States visas. Tinubu also tendered copies of reports of the Committee on Location of the Federal Capital of Nigeria and of Form EC8D of Kano State in respect to the February 25, 2023 presidential election, and that of Form EC8DA. Apart from the educational and travel documents, the court further admitted a copy of the originating summons of a suit instituted at the Supreme Court by the Attorneys General of Adamawa State, Akwa Ibom, Bayelsa, Delta, Edo, and Sokoto states against Tinubu. Also tendered was certified true copies of newspaper publications on several suits filed against the president by several groups. The counsel for Atiku and the PDP objected to the admissibility of the documents, while counsel for INEC and APC gave their consent for the documents to be tendered as exhibits before the court. Day 3 of the proceedings. The All Progressive Congress APC told the Presidential Election Petition Court that it will not participate in the whipping of dead horses, and it declined to open defense in the petition of the People's Democratic Party (PDP) and its presidential candidate Abubakar Atiku, challenging the conduct and declaration of the February 25 presidential election. APC counsel Lateef Fagbemi said there was absolutely nothing to defend in the separate petitions of the Labour Party and the PDP. The senior lawyer came to the conclusion not to open defense in Atiku's petition after cross-examining the Senate Majority Leader, Michael Bamidele, the star witness to President Bola Ahmed Tinubu. Fagbemi had subjected Senator Bamidele to rigorous questioning, during which the witness, who is a legal practitioner, admitted that Tinubu's election cannot be reversed on the strength of his forfeiture of $460,000 to the United States of America through the court order. The witness, while responding to Fagbemi's question, held that Tinubu was not arraigned, indicted, or sentenced for any criminal charges by any American court, adding that civil forfeiture cannot take the place of criminal trial and conviction. Earlier, the Senate Majority Leader had told the Presidential Election Petition Court that President Bola Tinubu does not need to score 25% of vote cast in FCT to be declared winner of the February 25 election. The witness, who was cross-examined by counsel for Atiku and PDP, said although Abuja is the federal capital of Nigeria, it has no special status other than that. He agreed with the petitioner's counsel that President Tinubu scored 19.4% in total vote cast in the FCT. After the testimony of President Tinubu's sole witness, Wale Olanpeku SAN announced the closure of Tinubu's defense, while Lateef Fagbemi SAN announced for APC. Meanwhile, the court has given the respondents 10 days to file their final written addresses and the petitioner 7 days to respond and 5 days to reply on point of law. Presiding Justice of the Presidential Election Petition Court, Justice Haruna Samani, said that the parties will be communicated on the date for adoption of the final written addresses.
Whatever has a beginning must have an end. Today, the proceedings in terms of hearing of the petition filed by Waziri Atiku Abubakar and the People's Democratic Party, the PDP, against INEC, against Bola Ahmed Tinubu, and against the APC has come to an end. We were able to call, that is Atiku and PDP were able to call 27 witnesses, some of them expert witnesses, star witnesses. In proof of our case, we tendered a deluge of documents which were all admitted and marked as exhibits in spite of strenuous opposition by the respondents. On the other hand, the reverse side of the coin is that INEC, on whom the burden of holding elections should actually lie as to whether the elections were free and fair, called only one witness. Secondly, the second respondent, Tinubu himself, only called one witness, Senator Michael Bamidele Okpeyemi, who yesterday was elected as the majority leader of the Senate. As to the strength or weakness of his evidence, that will be left to the tribunal. But the important thing is that we did grill him through the furnace of the fire to show that the evidence he gave was not credible, and to show that the documents he tendered, particularly the report on the FCT, as a symbol of status and as a fountain of unity of the country, which they themselves tendered, was actually in favor of the petitioners. We were also able to elicit from the witness that Tinubu did not win in his own state, and that he was the only presidential candidate that did not win in his own state. All others won. Atiku won in his own state, Peter Obi won in his own state, and Kwankwaso won in his own state. That he did not win there. We were also able to enlist from they witnessed that of all the presidential candidates since 1999, none except Tinubu was in a position that he did not score 25%. All of them scored 25% and over, except Tinubu, who had 90-point-something%. All these things were put in evidence today. I think we have run a good race. The judgment belongs to this distinguished and honorable Court of Appeal, which is the Presidential Election Petition Tribunal, to do justice to the case, which has been witnessed by the whole world. Thank you very much.